Great. Well, thanks very much for coming, everyone. Today's talk will be a journey into the world of M&A headed by partner of Skadden, Scott Simpson, and his colleagues Lorenzo Corte and Katie Brody. And the format will be in the form of a presentation, and we want to make it interactive, so please feel free to ask questions as you go along. There'll also be a chance at the end, and there'll be drinks as well for you to speak to speakers individually as well. Thank you very much.
Good evening, everyone. You're going to hear a couple of American accents, and although Lorenzo pretends to have an American accent, he's actually an Italian national with a US and UK qualification. I thought maybe we'd start a little bit just to give you some background on who we are, and then we'll set the stage for the discussion. We'd like to leave plenty of time for your questions, and as you just said, I think you should feel free to interrupt us. This is a topic of tremendous interest for the three of us. It's what we do. We love to talk about it, and I think you'll see some of that enthusiasm as we start. I've been in the UK now for 24 years, and I came to set up our M&A business here in the UK and throughout Europe. And very soon after arriving here, it became clear that having an American who transplanted himself from New York to London without a UK degree, there might be a challenge in actually building an M&A practice. And so one of the first decisions we took as a firm was to combine our US M&A capability and practice expertise with the very best UK talent, and we did the same in certain other jurisdictions. And that's because M&A cuts across borders, and to be effective you need to be familiar not just with one legal regime but with multiple legal regimes, and you need to be able to take some of the lessons from court cases in the US and some of the techniques in US M&A and bring them to the UK and vice versa. And so our practice, our M&A practice, this discussion is very much going to be a cross-border and comparative discussion around M&A, because it's, especially as the world has gotten closer and closer, there's no such thing as an M&A trade that doesn't cut across borders, and that's what makes it very interesting. That's what makes it very exciting. So I've been a partner at Skadden for more years than I'll fess up to, but I've been in these markets for 24 years. Lorenzo is a partner at Skadden. He will also not confess to how many years he's been a partner or how long he's been at Skadden, but fewer than me. And Katie is one of our star senior associates. She practices in the cross-border field, and so this is the trio that's here to present. Michael Hatchard, who was the UK side of this discussion, and we're going to do the best to fill his shoes. Michael is one of the senior partners running the Pfizer AstraZeneca project. We are, as a firm, representing Pfizer, so depending upon your views on that matter, you'll either think we're the devil or maybe a guardian angel. We'll see. We will be somewhat limited in taking questions on that topic, but I think we'll find a way to delve into it, maybe by comparison talk a little bit about Kraft Cadbury, which there are some similarities, not that chocolate and pharmaceuticals have anything to do with one another, but the way the bids are progressing, there are some similarities. Did I miss anything? Yes, sir.
So we start with the presentation?
Yeah. So since I've been chatting, why don't you talk a little bit about what's setting the stage for M&A?
All right. So we thought we'd start with some of the basic drivers for M&A, and let me start with the driver for maybe the Pfizer AstraZeneca deal, since it's relevant in the topic du jour, let's say. So the Pfizer transaction is driven by two, I think, principal objectives. Correct me if I'm wrong, Scott or Katie, if you think there are more, but the two principal objectives here are to and they're both strategic. One of them is to increase in size. Size does matter if you're a pharmaceutical company. There are significant advantages in combining operations and becoming sizable. Research and development for pharmaceutical companies costs a huge amount of money, and it is essential for pharmaceuticals companies to have, like Pfizer and like AstraZeneca, to have a significant amount of research and development going in order to keep at the forefront of the market. So that's clearly one driver. The second driver is a Pfizer driver, and this is a point of distinction, I would argue, between the Kraft-Cadbury transaction and the Pfizer-AstraZeneca transaction. It's a strategic objective, but it's a Pfizer strategic objective, which is to relocate its headquarters to Europe, in this case to the UK, in order to move out of the US tax regime as much as it can, and be able to utilize the cash that Pfizer has been accumulating in its international subsidiaries, which cannot be repatriated to the US without incurring significant taxes. By relocating through this merger transaction to the UK, Pfizer in several years will, and these transactions are referred to commonly as inversions, Pfizer will be able to utilize its cash in international subsidiaries without being taxed through the US filter, as it would otherwise.
Can I just elaborate a little bit? So U.S. citizens, I being one, we are taxed on our worldwide revenue. Wherever we reside, the U.S. government taxes to the max. U.S. corporations are not taxed on that basis. And to the extent they keep cash offshore outside the United States, they're free to deploy that cash, and as long as they don't bring it back, they're not taxed on it. There is a movement in the U.S. to perhaps change the tax policy, and that is causing U.S. multinationals, like Pfizer, but many others, to reconsider whether they are properly positioned under a U.S. parent company or whether they should move offshore. If you just move offshore, so you just decide 1 minute I'm a Delaware company, because that's what most U.S. companies are, so tomorrow I want to become a UK company, that's subject to U.S. tax. But if you can find an appropriate merger partner, in this case let's call it AstraZeneca, and you can merge into that entity, you migrate, you move yourself offshore in a tax-free, on a tax-free basis from a U.S. point of view. And it's just one example of a big driver, but if you now armed with that, if you look at the newspaper, you'll see countless examples, too dramatic, many examples of cases of U.S. companies that are going to Ireland, U.S. companies that are looking at Luxembourg or the Netherlands.
Fiat Chrysler, another example.
So, and this is just one driver. Let's talk about another typical.
But I just wanted to dwell on
go
that
ahead.
for a second. So, and this will come on, it will be relevant later on. So, politically and also strategically, the Kraft-Cadbury transaction is distinguishable from the Pfizer-AstraZeneca transaction, because from a UK perspective, what the UK is getting in the Pfizer-AstraZeneca transaction is a monster of a company that will be headquartered in the UK, and therefore there is arguably no loss to the UK. In fact, there is a gain from a UK perspective. In the Kraft-Cadbury transaction, if you want to look at it from a sort of UK policy, political perspective, Cadbury was mopped up by a US buyer, which had no intention whatsoever of relocating to the UK. So that's a pretty significant difference between the two transactions from a UK perspective.
It is, and it highlights another driver. So let's talk a little bit about consolidation. For the last couple of years, our firm has represented a Finnish stainless steel company, which acquired ThyssenKrupp, which is probably a name you're familiar with, one of the largest stainless steel and steel producers in the world. The Finnish company bought Thyssen stainless steel for one reason, and that's because in stainless steel it's a global market. Competition is coming from Asia, And unless the manufacturers of stainless steel in Europe consolidate, the argument goes, unless they get bigger, they'll be unable to compete against big Asian and South American players. And so what drove that merger was completely different from, say, the Pfizer AstraZeneca situation. This was a mere consolidation where you have to look at competition policy, antitrust rules. Can you combine companies, or is that going to hurt the consumer, and you get the antitrust authorities involved?
Everyone. I mean, there are
I
other
think so.
there are other drivers. You know, geographic expansion. You know, rebalancing your balance sheet. If your balance sheet is full of debt and the target instead is very healthy, you merge and the companies combined have a better overall picture. I mean, there's n number of reasons why you would want to do an acquisition or a merger transaction. Should we go to the different regimes, perhaps?
Yeah, and so I think maybe we just use, having said, we told Felix we weren't going to be able to talk about Pfizer, AstraZeneca, that's what we've talked about so far, and probably we'll keep using it. But this is an academic setting, and you won't hold it against us, I'm sure, and you won't report to Pfizer that we use the case as an example. The three of us are not involved, so we can talk about it. But it highlights what I said in the beginning. The merger practice, and it's one that I hope you all decide that you'll walk out of this room and say, God, I want to be a merger and acquisition lawyer. We'd be delighted if you had that kind of enthusiasm. But one of the reasons that it's an exciting place to practice, either as a lawyer or as a banker or as an executive, is because of this cross-border component. And just look at Pfizer, AstraZeneca, right? Huge U.S. company domiciled in Delaware in the U.S. acquires huge UK company. So you're the lawyer involved. What does that mean? You need to be fully aware of all of the legal aspects of Pfizer's bid and merger proposal to AstraZeneca. You need to be familiar. What are the board members thinking about? What are their duties? What's the regulator, this takeover panel that we hear about in the UK? What's its role? What is it thinking about? Then back at home, Pfizer's got to worry about, it's a public company. It has public company shareholders. It has its own board. How high can Pfizer raise its bid? What are those directors thinking about in terms of their fiduciary duties to their shareholders? Can they afford to pay what AstraZeneca says it must have to satisfy AstraZeneca's shareholder demands? Can Pfizer agree to whatever the requirements are that come from the UK government, because it's being hotly contested? So this is what makes the practice so dynamic.
And you know, our role is not just to advise on what the rules are or what the latest court decision is on whether you can, you know, increase the price or not increase the price, or how long you have to increase the price, or you know, whether you can put out a press release, what the press release can say. That's a small part of our role. When the advisory team, which is constituted by lawyers, most of the time in a transaction like this, bankers as well, and so on and so forth, is a combined team that combines, you know, I'd say multidisciplinary advice. You know, it's legal, it's strategic, it's business, and the roles are defined to a point. But you know, when you've been doing M&A transactions like this, or public M&A transactions for you know, several years, it just becomes general strategic advice that you're giving, more on the legal side on our side, more on the business side on the banker side. So it's a role that goes beyond just the rules and the decisions and so on and so forth.
And if you don't keep these dueling responsibilities of different regimes, if you don't keep them in front of you all the time and appreciate the differences and how you can get in trouble if you leave something out, you suffer, say, what Kraft suffered in the Cadbury takeover. So what did they do? They, because of the political pressure, chocolate is obviously a very important thing from a UK point of view. Cadbury chocolate even more so, just like Danone yogurt in France was protected as a national treasure. So Cadbury became very important. Well, what did Kraft do? Kraft sort of bent to the political pressure, and they said going in, they said, you know what, this plant that Cadbury had said that they were going to shut down, if Kraft is allowed to take over Cadbury, we're going to keep that plant up and running, we're not going to lay off any people. Now in the US, there are certain ways that you can make a statement like that and express it as a current intention, and that might change. And in the legal regime in the US, you probably get away with it. Well, what happened here, that promise was interpreted by some politicians exactly for what it was. It was a promise, we will keep the plant open. The day after Kraft took over Cadbury, they shut the plant down because they learned in diligence that there was no machinery in the facility. It had all been shipped to Poland. So this facility that they were going to keep operational and that they promised, and these jobs that they were going to protect, there was nothing. The plant was sort of empty. So they said, we're closing it. And that created the furor in the government over the whole takeover. That created a whole government review of takeovers generally in the UK and precipitated a change in the rules that in the Pfizer AstraZeneca situation, they're having to deal with new rules because of some of the footfalls during the Kraft Cadbury case.
Let's give a general overview of the differences between the US and UK and European public takeover systems, just generally. Maybe Katie can start with the US.
So in the US, there are essentially two bodies of law that you have to deal with in takeover transactions. The first being the state corporate law. So if you're a Delaware company, you turn to the Delaware Corporate Code. If you're a New York company, you turn to the New York Corporate Code. So, you know, although there's obviously 50 different regimes there, everybody really follows the Delaware courts because it's the most sophisticated. They have the most M&A activity. They have the most sophisticated judges. So that's really where we look. But you turn to the state corporate codes to look at the internal affair issues of the company. So things like fiduciary duties of directors during the course of a takeover, shareholders' rights, the mechanics of a merger. Those would all be governed by state law. And then on top of that, you also have to consider the U.S. federal laws. So we have a Securities Act and an Exchange Act that govern things like disclosure, the takeover mechanics. How do you actually make a takeover bid, what we would call a tender offer in U.S. jargon? How do you register securities if you're offering shares instead of cash as consideration in a transaction? So you have to keep in mind that there's two bodies of law that you have to refer to in the U.S.
And in Europe, it's largely the same. I mean, in the U.S., the bodies of law that Katie is referring to in terms of the securities bodies of law were set up in 1933 and 1934. In Europe, they were set up in 2005 and 2006, so we're a little bit behind the curve. But we have a system that is largely similar. So in Europe, and that includes the UK for these purposes, there is, from a takeover perspective, something called a European Takeover Directive, which is a body of law that sets out the general parameters of how you do a takeover, essentially. And it's a minimum standards directive. It was implemented, it was issued in 2004, it was implemented by 2006 by all of the member states. And it's really just the basic parameters of how you do a takeover. And in that, it's similar to certain provisions of what Katie referred to as the U.S. Exchange Act. We also have in Europe something called the Prospectus Directive and Prospectus Regulation, which is a set of rules that govern what you have to say to the public, what you have to disclose to the public when you issue shares to the public. And that's relevant in a takeover context, because if in a takeover context, instead of offering cash, you're offering shares as consideration, you've got to abide by the rules of the prospectus regulation and the prospectus directive. Going back to the takeover directive, the takeover directive, and this could be a point of pride for the UK, is inspired by the UK Takeover Code, which is the most sophisticated body of rules, and has been the most sophisticated body of rules in Europe on how you manage takeovers for the past 40 years. And so there are, when the Takeover Directive was finally adopted, Europe argued over the Takeover Directive for 16 years, as only Europeans can do. But when they finally adopted the rules, if you
We
read...
have the Europeans say things like that, not the American.
Yeah, no, I'm Italian, I can defend myself. So if you look at the European Takeover Directive and the UK Takeover Code just before the European Takeover Directive was adopted, they read in very similar manners, and some of the basic rules are exactly the same.
Can I
The
interrupt
only
for one
issue, yes, sure.
second? So, we talk about this European Takeover Directive. I just want to put it in a little bit of context for you. How did the European sort of experiment begin? And it began with competition policy, where I think a number of people decided if Europe is going to compete in this world, it's going to have to begin to compete as a single economic community. Otherwise, it's going to get picked apart by either the US or South America or Asia or what have you. And so competition policy was decided. Competition policy should cut across borders. We shouldn't allow individual nations within Europe to set that policy. We should let Brussels set it. But that was the first move. Then someone said, geez, that's really not enough. We need to figure out kind of what the US has done. We need a framework that allows companies from different countries in Europe to begin to buy and sell one another under a common set of rules, so that a UK company doesn't show up in Germany and be told that the rules are completely different. And so the vision was European directive. We all know what, you either love or hate European directive, but the concept was a unified structure for how the mechanics of a merger. And that is what precipitated the debate, because certain countries, in fact it was Vodafone's bid for Mannesmann. You're all too young to have lived through the takeover itself. However, it precipitated a huge controversy in Germany. Vodafone took over Mannesmann, huge German telecom company, and once it was acquired, the German unions went crazy. They said, we can't let General Motors take over Volkswagen, for instance. And that stopped the European directive until a compromise could be fashioned. But this is the debate that's been raging in Europe for the last 20 years. Sorry.
And the system, we said, just a few more words, we said the systems are comparable because there's a federal overlay, and then there's, the national members in Europe each have rules that govern corporations and fiduciary duties and so on and so forth. The only difference is that in the US, you have, a federal system and a federal government that enforces it through federal courts. And then you have one state that actually dominates corporate law and sets the rules that every other state follows. In Europe, it's very fragmented, because what you have is you have general directives on how the rules should be. Then you have each nation sort of interpret those rules and issue their own body of law. And then the courts of those countries, which have varying levels of sophistication, because, for every 20, 60 takeovers that happen in the UK every year, there is one in Romania, or, Poland, or 0 in Lithuania, or 2 in Italy. So, the sophistication of courts and the amount of precedents that are accumulated is very different, and the results vary dramatically. So there is very little uniformity in Europe, is the message I'm trying to pass along, while there is much more uniformity in the US.
Yeah, and I think while we're sort of comparing and contrasting, it is the rare takeover in the US that causes there to be a huge political debate. Right? We've had probably in the last 2 years. Yeah, we had Dubai ports many years ago, but this is the point you made to me the other day. In the last 2 years, we've probably had a dozen big US companies leave the US through mergers because of this tax advantage we talked about. Has there been an outcry, a change? Do you turn on the TV? Like You will leave here tonight, perhaps turn on the TV, and you'll hear a debate over whether we should allow Pfizer to take over AstraZeneca. It's extremely rare in the US. And I would say up until very recently, it was extremely rare in the UK by comparison to France, where everything is a sacred,
Strategic company.
strategic company, or Germany, where they will rally to support their companies. And so, if you compare and contrast from 70,000 feet, you would say government intervention is regular in Europe, not so regular in the U.S. outside of certain pretty narrow exceptions. Now let's talk a little bit, because Lorenzo said the UK, by and large, has been the model to try and drive uniformity in Europe. So let's talk about the UK approach. The UK approach to takeover regulation says that there is a regulator, in this case called the Takeover Panel. That panel will make critical decisions as to the conduct of the bidder and the conduct of the target board. Sets the rules, says what you can and cannot do. There's sort of guidelines. By and large, strips the board of directors of a company. So AstraZeneca does not necessarily have a lot of power to put impediments in the face of Pfizer. Whereas in the US, number one, our regulators do not regulate the conduct of a takeover bid. We have a very different system. We have a very sophisticated court in Delaware, where 90% of the companies are incorporated, and that court will hear during a bid arguments by a bidder or by a target. The bidder may come in and say what the target has done to try and stop the bid is outrageous and needs to stop. The court in Delaware will take immediate jurisdiction. It's a court of equity, patterned after the equitable courts here, but in the US it has the power to actually intervene and sort of moderate any disputes between bidder and target. Here in the UK, the courts play no role in the conduct of the bid. Now, if the target directors abuse their powers, the courts will review their conduct, but not during the bid, only afterwards. So you might have board's conduct reviewed 2 years after the fact, but not during a bid. During a bid, the takeover panel will listen to complaints, if there are any, about the conduct of the parties, and make a ruling. Nobody goes to the courts.
It's a fundamentally different approach, and we'll go through a couple of specifics with Katie, but fundamentally the difference in approach can be summarized in this. The UK, and therefore the rest of Europe, most of the rest of Europe, takes the perspective that it should be the market that decides whether a bidder should take over a company or not. The market being the public shareholders of the target company. And so therefore, the board of the target company should not have any ability to interfere with the bid or frustrate the bid. The only thing that the target board can do is say, yes, it's a good bid, no, it's a bad bid, or perhaps go and find another bidder that will compete with the first bidder. That's the role of the board in the UK. That's the role of the board in most of the rest of Europe. In the US instead, and that's because in the UK and in Europe, the principal body that governs a company is not the board, it's the shareholders meeting, it's the body sort of congregates all the shareholders. In the US instead, that function is given to the board, is entrusted to the board, and the board is the actual gatekeeper for the company itself. So when a bid is made, it's the board that has to decide whether the bid is good for the company or not, and therefore the board is given instruments to block a bid unless it determines that it is a good thing for the company. That leads to differences in results that we'll debate in a second, but perhaps if you take us through a couple of sort of duties of the US board that we can compare with that.
Sure, absolutely. So, as a director of a US company, there's essentially two main duties. Your duty of care, so acting on a reasonably informed basis, and your duty of loyalty, so putting the interests of the company ahead of your own and acting acting in the best interest of the company. It sounds quite simple, but those are actually the two rules that most of the M&A litigation in the state courts hinge upon. In the context of a takeover or a change of control situation, meaning where the company, its board, has decided to put the company up for sale, or has said, we're going to abandon our strategic idea here and go for a breakup of the company, or has otherwise approved the takeover. At that point in time, those two duties crystallize into one specific overarching duty to maximize and get the best possible price for shareholders. And so this is called the Revlon duty. It's based from an old case dealing with the takeover of Revlon. And this is a duty that essentially trumps all the other duties that a director would normally have. I mean, it trumps duties the company might have to its creditors, to its employees. I mean, this is the number one focus in the context of a change of control that directors should be concerned with, maximizing the price they can get for their shareholders.
Can I stop you there for a second? So comparing that. So again, you're in the US, you decide to sell a company, your only duty is to maximize the value of the shares of the company for the benefit of the shareholders. That's it. There's no other duty that matters at that point in time.
And if you have two bids, you gotta take the higher bid.
Correct.
Even
There's
though.
no independence.
Even though the lower bid means more jobs, or it means the company's not gonna have to uproot itself and move to California or something, no matter what, highest price wins. So long as, and Katie referred to a change in policy, or you decided to sell the company. If you decide in the US to maintain your independence, I'm not gonna sell to anybody. The courts allow a target board to put any number of obstacles in front of bidders, so long as they decide, exercising their fiduciary duty, advised by very good lawyers, hopefully this firm, as long as they follow that advice, they are allowed to put roadblocks in front of any bidder. In the UK, you can't do that.
Okay. First, in the UK, there's no Revlon duty. So in other words, you decide to sell the company, okay, you can change your mind. You can advise, your shareholders that none of the bids that were made are good, that it's better to remain independent. You can't put roadblocks, as we discussed, but you don't have a duty that trumps all your other duties to maximize shareholder value. You continue having your duty of care, your duty of loyalty. You owe your duties to the company and all of its stakeholders, not only to the shareholders. And that just doesn't change. So that's one point of difference in terms of the approach of a UK board to one or more bids, as opposed to the US.
Right, absolutely. And then just in terms of how a court, so if for instance there's a transaction, the board approves it and somebody challenges the decision of the board to approve it, it goes to a state court. What's the judicial review? What's the standard by which the court is going to look at this and try and determine if in fact the directors have abided by their fiduciary duties? Well, just to give you a sense of perspective, the overarching general rule is something we call the business judgment rule, and it's a presumption by the courts that the directors have acted in accordance with their duties. And in the general case, absent of showing that their actions are irrational or just blatant waste, the court will just defer to the decisions of the board. This takes on a slightly different view when you have a situation where you're trying to implement a defense. And this is because there's sort of an inherent conflict when a board is faced with a takeover. I mean, some of them might be management and they're obviously worried about their own positions. And it's also just such a fundamental, day in the life of a company that when looking specifically at defensive measures, so any actions to frustrate a bid, there's actually a higher, or what they call an intermediate standard of review. And this is after a case called Unical. It's an old case dealing with the takeover of Unical. And in this case, instead of saying, okay, we defer to the general business judgment of the board, they say, hold on, we're going to take a look at this defense that you've put up, and we're going to ask, is there a reasonable reason that you put it in place? So is there a threat to corporate policy? This usually just means, inadequate coercion to the shareholders? Is there some sort of cognitive threat? And then the second thing they'll look at is the measure that you put in place proportional? You know, is it justified given what the threat may be? And so based on that test, they'll determine if the defensive action taken by the board to frustrate the bid is acceptable or not.
And for example, one of the ways they measure whether the takeover defense is proportionate is to look at whether it's a permanent measure, whether it has a, usually it's, takeover measures work defense measures work if they are temporary. If they're used to temporarily stall the attack until such time as the bidder goes away, or there's a better bidder, or the shareholders manifest an intention to, keep the company going in an independent sort of manner.
So let's flip it to the UK, because we've said defensive measures, frustrating a bid. It's not available to a board. But we all read in the newspapers, there's pressure coming from the government and from various lobbyists and parts of the public saying, we don't want our UK companies to be taken over by foreigners. But we have a system that doesn't allow the board of the target to put up roadblocks. So what happens? As a result of Kraft Cadbury, fundamental changes were introduced. And what did those changes do? They forced the bidder to really move very, very quickly during a limited period of time. And you'll see this in the news reports probably tonight, tomorrow, that Pfizer's time to put up or shut up, to make their bid or not, is winding down. Very, very finite period of time for a bidder to get all of its financing. In the UK, you can't just say I'm going to make a bid. You've got to show a bank that you have all the money lined up, held in a bank account, it's got a little ribbon around it, and you're ready to go. That's got to be done, unless the target says otherwise, that's got to be done within 30 days. And if it's not done in 30 days, you got to walk away. So there's tremendous pressure that's been put on bidders, which makes it very difficult for them to do what Pfizer's trying to do. That was the approach that was taken post-Kraft Cadbury, not to allow an even more what would have been really a change in the whole system, to allow, in this case, AstraZeneca to put up roadblocks and frustrate a bid.
So can we spend a little bit of time on that? I mean, when Kraft Cadbury happened and the discussion turned to, oh my God, after 40 years we realized that we have a rule that says that we can't frustrate bids, and so all of our companies are going to be taken over.
Which, by the way, was the argument Vodafone. They were very happy to say I'm honest by
not sure why.
We can't frustrate a bid because we want to take you over.
Yeah, I'm not sure why the chocolate company. Anyway, but so when this sort of debate started, all of a sudden, then the debate started as to, okay, what do we do? And so we got called in to talk with the Takeover panel and to talk about how the US works. And we said to the Takeover panel, well, the way you would do it is you would allow the board to defend. And if they defend inappropriately, you shut them down. If they don't defend inappropriately, then you let them defend. And you move on, and you let the markets play that out. And the arguments we used are, look, in the US you can use defenses. It's not like there are no takeovers happening. I mean, it's one of the most active markets in the world, if not the most active market in the world. And it has been forever, and it continues to be. So it can't be all that bad for a target board to be able to defend. And we argue, so what's wrong with allowing a board to defend in the UK? So that fell a little bit on, and we even organized a meeting between what is now the Chancellor of the Supreme Court in Delaware, a guy called Leo Strine, and the head of the Takeover panel, to work this out and understand how the US system works and why it works. But what the UK did, instead of sort of implementing a system that drove in that direction, is to make it really difficult for bidders to make a bid, which is a little bit counterintuitive, at least from my perspective, personally. And so what you've got is Pfizer right now putting together what is now a $109 billion bid, and I can't tell you how difficult it is to do that. Working out where part of the consideration is cash, so they're looking at raising huge amounts of money from in loans and from their own cash, but it's just an extremely complicated exercise. And also setting themselves up to issue shares as consideration, because the consideration is mixed, which is a very complicated exercise as well, all in 30 days. I'm not sure that benefits the market all that much.
Just a quick question.
Yeah.
So are you saying that 30 days is too short, or that this rule shouldn't exist? Because I'm not really sure what you're getting at. Is it maybe 60 days? Or maybe no rule?
It's
Great question.
a great question. So part of the problem here is we're biased. I mean, 24 years in this market, I still think,
Okay.
give the board the power
Yeah.
to say whether, because it knows the company the best. So give them the power to delay. Give AstraZeneca the opportunity to say, you know what, this bid's not high enough, and we're gonna put some measures in place on a temporary basis to see, for instance, whether our independent program is better or whether there's a better merger partner with Behemoths. But to go to the heart of your question and try and answer it directly, I don't think we're not big fans of the rules that came in post-Kraft Cadbury, because it makes it very, very difficult for bidders. And how do you get out from under it? And this was I think this is the sinister part of the law. And here's where you actually do give the target board of a UK company power. The power to extend that 30 days is given to the target board.
Okay.
So they're not allowed to put impediments in place of something they don't like, but if they do like something,
They can give it to
so if AstraZeneca all of a sudden decides, 109, that wasn't good enough, but 120 or whatever, we like that, then boom, that 30 days gets extended. And that's the way the Takeover panel, which is a super sophisticated group of regulators, right? And that's the way they decided to handle it. Which system's better, I don't know. I think the UK system works really, really well. US system works really, really well.
The UK system worked really, really well until 2010. It's largely untested as it is now.
Fair enough. But I think having a sophisticated regulator, so if a bidder's upset with something the target's doing, the bidder just picks up the phone, calls the panel, and they get a ruling. In the US, we don't have that. In the US, what do? We wait for the directors. If they've made a mistake, we wait for the mistake, then we call up the judge in Delaware, we have to get an emergency hearing, he has to take the case. So it's not as ideal as a phone call to the regulator saying, this is an abuse, fix it.
But from the standpoint of shareholders, let me argue it from the standpoint of shareholders, okay? There's a lot of concern with defensive measures in the UK, and look, I'm both in New York and an English lawyer, and I do transactions on both sides of the Atlantic, as does Scott and as does Katie, and I've seen, but I struggle to think about one transaction where the consideration that was being offered was good for shareholders, for the target shareholders, that didn't go through, even if there were defensive measures set up.
In the US.
In the US or Europe.
Mm-hmm.
I mean, Scott and I, in 2006, led, I think, what is one of the most vigorous, I would call it vigorous defenses
Use the word aggressive.
of a company,
Defenses of it.
defenses of a company ever in Europe. I mean, we defended a company called Arcelor against a takeover bid by another company called Mittal. What that resulted in, and that was aggressive as a defense, it really was. I mean, we pulled out everything. But after 6 months, Arcelor was taken over by Mittal, but only after Mittal offered a 100% premium.
So another $25 billion went to
Right,
Arcelor shareholders, and that's why we think, let a board defend until they feel the pressure of, oh my God, the price is so high that if we don't sell to you, we won't be able to go to the grocery store because the person in the grocery store is gonna say, I own some shares, I'm gonna murder you, right? I mean, that's what it's, that's the pressure.
But that's what it's about. I mean, the fences are not there
Okay.
to maintain, I mean, this idea that the fences are there to entrench a board forever, and you see, you know, board members 115 years old and they're still there, it's not what the fences are about. The fences are about giving instruments for a company to put itself in a position where it can be sold for more.
But just to elaborate on this point of pressure, so Arcelor was a Luxembourg company, it was entitled to defend. So even though this framework across Europe patterns the UK model, companies were allowed on the rule of can you frustrate a bid or not, companies and countries were allowed to opt in or opt out of that rule. So in Luxembourg, Arcelor was entitled to defend, and boy did it defend. But once the price got to a point where the board, looking at their duties under Luxembourg law, said, geez, we've got to let shareholders look at this seriously. The other thing Mittal did was he said, you know what, I no longer want this to be a Dutch company, which is where he was registered. He said, I'll be a Luxembourg company.
He inverted into
So
Luxembourg.
he inverted into Luxembourg. And he said, you know what, on employment, I'll put the headquarters here, I'll do, so he made.
I won't fire anybody in France. He said that.
He made all of the changes, he made all the changes that you could want. At that point, the board is not gonna hide behind its defenses. It can't because of its own fiduciary duties. And that's the way the system works in the US.
Yep.
Yes, we can defend, yes, you can put up horrific barriers from a UK point of view. But at the end of the day, if the directors prevent shareholders from getting a compelling bid, they get hauled into court and they have personal liability. And that's what gets their attention.
One word on the UK. I mean, the UK, and this is the problem with the rest of Europe. In the UK, the system works well.
Okay, we have got a lot of questions.
Okay. The system works very well, and the reason the system works well is because we have here the most sophisticated capital markets, you know, probably in the world. The London Stock Exchange and the capital markets surrounding it are extremely sophisticated. The investors are extremely sophisticated. So when a board turns around and says, "Don't tender into that bid," it's absolute crap. Excuse me. The institutional investors will actually listen, and it's not unprecedented for the board to be the bid to be unsuccessful just on the basis of the board saying that bid is inadequate. So we won't defend, but we're not going to. But
Okay, but Lorenzo, I
when
hear.
when you export that to the rest of Europe, I mean, frankly, so let me talk about my country. The Italian capital markets are not as sophisticated. I'm just going to admit that. and the Polish capital markets are even less sophisticated. And some of these countries don't even have capital markets. I mean, they have stock exchanges with 15 companies listed on them. So that system doesn't work, and it doesn't work in those countries because you don't have a sophisticated regulator. You don't have the UK Takeover ban. You have a bunch of people who regulated one case in 2 years, right? So, questions? Otherwise,
Debate.
Sorry, just a question that's probably going to matter more to the lawyers and the audience. I do E&M, I'm just going to be nice. So you guys are talking a lot based on business issues, business defense is M&A. But I guess all of you are trained in law. What was it like trying to learn the business side of things? Was it enjoyable? Do you feel like tearing your hair out? Or
I think what attracts this practice to a lawyer is the business side of it. But actually, why did you do that?
I mean, quite frankly, I think especially at this level, the deals we're working on are so, high profile, highly sophisticated. I mean, it takes somebody with a creative mind and sort of an intellectual leaning to do this kind of work, and you're constantly surrounded by smart people. I think it's a very interesting, if you're a hard worker, it's a very interesting field to go into. And the business stuff, it comes in time, and you're not going to be an accountant overnight, or probably ever if you're me, but you know, you work with other financial advisors and you get support elsewhere, so I don't think you necessarily have to have a finance background to go into law. I certainly don't, but you know, a lot of it comes with the job.
I did, so I got my MBA when I was getting my law degree. So that because I came out of university as a political science major with, but it probably resonates with actually no skill. And unless I wanted to be a politician, which I wasn't going to be. So I decided I was going to law school. I thought I might want to be a corporate lawyer, and so I got a business degree, and that helped me a little bit. But the perspective of our firm is, you know, if you have an interest in this area, you learn the accounting that you need to know, the financial statement understanding that you know.
So let me give you, can I give my perspective, which was completely opposite to yours?
Doesn't surprise me.
And it doesn't help, and it didn't help me at all. So a warning to the wise.
Yeah.
So I studied criminal law in Italy, and I was a criminal food lawyer for 2 years. I decided to be a corporate lawyer because that was the job I got, and I didn't want to go back to Italy yet after I took my master's, and so I was going to take anything that was offered to me. And so when the partner that interviewed me said, "If have you always wanted to be a corporate lawyer?" I said, "Absolutely."
Who is one of our partners?
I started a week later, and one of the partners walked into my office and said, I knew nothing. I mean, nothing. He walked into my office and he said, "So Lorenzo, are you ready? Because we're going to go on a business trip on Friday, and we're going to work on a convertible." And he dropped on my desk a number.
This is not an
Bunch of-
automobile.
A bunch of papers like this. And my thought process was, what's a convertible? And I started calling people around to actually figure out what the hell a convertible was. It turned out it was a convertible bond issuance, which is actually a very complicated thing. But I had to study accounting on my own, sort of with a little candle burning, and it was not the easy way of doing it. I would recommend.
The one thing I would say is, although business is important and and the strategic side of all of this is very exciting, the law actually is critically important to this practice, and a lot of fun. And so one of the things you can do is you can take some of the learning from, for instance, a case you've done in Holland, and you can take that learning and go into Luxembourg and create a nasty, nasty device to put in the way of Mittel. And all of that was law. There's no business. The business objective was, we were told by the board of Arcelor, buy us 6 months. So that's what
Because we want more money.
We
Even
want
without a business degree.
we want more money. Give us 6 months. Buy us time. We need to find out if there's anybody that's going to pay more than Mittel if we're going to lose our independence. So what did we do? We tied Mittel up in knots in the U.S. because his bid required compliance in the U.S. at the same time he had compliance in the Netherlands, and the same time he had issues in Luxembourg. It was all legal strategy to slow his bid down. All done for the right reasons. There was nothing bad about it. It was all legal stuff, and really kind of a lot of fun and creative.
I mean, in the context of non-public deals, so when you're doing an acquisition of a private company or a private set of assets for a client, that's where I personally think accounting becomes, and business, but more accounting, becomes very, very significant. And if you don't have a basic understanding of accounting, or actually a relatively, over time, sort of sophisticated understanding of accounting, you're going to have big limitations in terms of what you can contribute to a transaction. And I feel that firms like ours, but several others operating in the same sort of playing field, have a advantage over, oftentimes I find, over smaller firms, less specialized firms, particularly in Europe, in continental Europe or so on and so forth, where lawyers are lawyers and they just don't have the exposure to accounting that we have. And so when the issue is sort of an issue relating to depreciation or to sort of amortization or goodwill, which can change the dynamics of a transaction completely. You know, it can suddenly not make sense at all to do a deal from one day to the next. And you know, you got to understand that. You can't just sort of go like this. Otherwise, you can't protect your client. You can't legislate. Please.
This is no, sorry. I thought you were like I've got another question, but
Go ahead.
Yeah, go ahead.
I was going to ask about this is more than sort of UK, US in terms of activist investors, which is quite topical at the moment. I was just wondering how the legal environment in the US sort of facilitates active investors more in the US than over here in the UK, because we do see most of active investors active in the US rather than in the UK, and yeah.
It's a great question, and in fact, behind your question is an issue that is now the most, I would say, controversial issue in the U.S. markets. And there are commentators and practitioners who are basically saying, and judges that are saying, enough is enough. Activists have too much power. In the U.S., almost every board is elected on an annual basis. It gives activist shareholders tremendous power to influence the shape of a board on an annual basis. And so the question is, in the U.S., what can be done to help boards withstand the pressure of activists who are, and now we'll bring it into some of the debates here in the UK, who are short-term shareholders, right? That ugly word that's bandied about in the hedge funds, short-term shareholders. That they just want a quick buck, right? As soon as they jump into the AstraZeneca stock, they change the stable shareholder base that Lorenzo was talking about, and they'd be more interested in selling to Pfizer because they just bought on speculation. The same debate's going on in the U.S. in the context of activists. What do you do? And the problem is, in the U.S., there's not a lot that a board can do to fight an activist shareholder. You have, as a board, power against a takeover bid. But you don't have that much power over the election of directors and activists. And so the best defense in the U.S. is the board's communication with shareholders and the board's continued good performance. And if they have lousy or shitty performance, they're going to be vulnerable. But it's a huge debate. What more can be done to give companies in the U.S. tools to defend themselves against not just takeover bids but activists? I don't know if you want to comment on that.
Yeah, no,
in the UK, where it's huge.
Yeah, I think actually that historically activism has been more of an issue in the US because the US has a tradition of being, or has had a tradition in the last 30 years of, forgive me the term, being less clubby and more sort of open to whoever, or, it's a bit more of a jungle thing. I think one of the big debates raging in Europe, and in particular in the UK, is that activism is expanding to Europe in a big way, big way. So I don't think your question was a great question, I don't think the premise of it, which is that in the US there's more activism than here, will be a valid premise for much longer.
It's certainly true today.
It's certainly true today.
But it's not trending that way.
But it's trending towards a huge increase in activism, because the UK has the most open and sort of receptive and sophisticated capital markets in Europe, but also in other countries. In France, there's a lot of activism. In the Netherlands, in Germany, in Switzerland, in Norway of all places, I don't know why. But there is activism. I mean, one of the instruments that you have in the US that you don't have to the same degree here is litigation, right? It is much easier to sue in the US.
What, an activist? You mean if he or she's misbehaving?
Or an activist,
Yeah. So activists can, if they're unhappy with the board, they can bring an action in a court and accuse the board of breaching its fiduciary duty. There's nothing that gets somebody's attention more than a lawsuit that threatens their personal.
And that in Europe just is not. We're not there yet. That not there yet. It's more PR and campaigning, but that can put a huge amount of pressure on the board, right?
I mean, one of the things, Lorenzo said that the trend is going in a different direction, and you just need to look at another live case that's in the newspapers every day now that we're involved in, and you see us in a role that's quite unusual for our firm. There's a company called SR, which is controlled by a majority shareholder, and the majority shareholder wants to take the company private and delist the shares. And there is a institutional investor, so not the hedge fund short-term shareholders, if you want to use the pejorative terms, but there is an institutional investor group here called the ABI, and the ABI and institutional shareholders have become very upset with the way SR is going about its take private. And what have they done? Well, they hired Skadden Partners, they hired a law firm to try and help them organize themselves. So this is not an activist shareholder, if you want to, or like use the pejorative. These are big institutions in the UK that are just unhappy with what's going on. They organized themselves as a consortium. They hired a law firm, and they're fighting the target company. And that's why we say the trend is probably it's likely to come here in a big. It's already here, but it's likely to increase the way it has in the U.S. How it's going to get slowed down in the U.S., I don't know. But they're talking about, they're talking about we need to do it. I'm not sure that's right or wrong, but they're certainly talking about it.
And the role of activists is also evolving already. I mean, it's it's easy to portray them as they're portrayed.
Yeah, it's not a dirty word anymore.
It's not a dirty word, number one, and number two, hostile takeovers were a dirty word in the 70s and the 80s, and they're sort of regular stuff nowadays. You look at, for example, in the U.S., there's another, very big takeover.
Sorry, just to illustrate the point, one of the defenses that Cadbury couldn't use against Kraft, so Kraft launches a hostile bid. What would be the first thing that you would do? You would say, that's outrageous, how could Kraft? Why did Cadbury not do that? Because Cadbury had done hostile takeover, so it's like, in order to build that.
There's a hostile takeover now taking place, unfolding in the U.S., which is very, very weird, with a strategic investor, a company called Valiant, that tied up with an activist shareholder to do a takeover bid that is something like I can't remember if it's $50 or $60 billion. We're talking huge, biggest deal around in the U.S. right now.
That have Botox and
Correct.
Parmesan and
Correct.
And can I just make a commercial statement? We're 10 minutes over, so, and you all probably have we're gonna sit here, we love talking. I warned you, and in opening comments, we love talking about it. You're free to stay, and we can ask questions. You're free to here we go. And so anyway, we can keep going. I just didn't want anyone to say, oh, Jesus, one of these guys gonna shut up. Sorry. Yeah.
Given that the timelines for completing a takeover are only 30 days, how big is it a challenge to conduct legal due diligence, besides using tools like representation, warranties, indemnities, doing actual legal due diligence?
Yeah, it's a great question. It's impossible. I mean, and that's the nefarious part of the rule, right? If a target is not willing to consider the bid, it sticks with this 30 days. And it doesn't have to extend it. And in 30 days, all we can do is, right, where you get the phone call on behalf of the bid, so do your due diligence. Oh, what? You look at the public statements. That's what you rely on. You bid on, and you hope that the management has taken the public statements seriously, and that they've disclosed everything there is to disclose, but you're not going in and looking at the facilities, as was the case with Kraft, right? If they had done due diligence the way we know it in a private context, they would have known that there was no machinery in the plant that they said they were going to keep open.
Okay, but I'm gonna take the UK side of the argument on this one. I can't do a UK sort of accent, but
Okay.
anyway, but,
No, and you gotta work on your American accent.
that's true. So look, but you know, a supporter of the changes to the takeover code would respond and say, okay, but let's look at it. So if you're doing a hostile offer, forget about the 30-day rule. If you're doing a hostile offer, you're not gonna get access to due diligence, whether you like it or not. Because there is no board that is required to open up its books in a hostile situation. You can sit out there in the cold and make an offer, but you're not coming in until we say that. If it's a friendly offer, the board will open up the tent and will say, oh, and because it's a friendly offer, we'll give you another 30 days and maybe another 30 days, and so you can do your due diligence. So on that specific question, I think that's how the takeover panel would justify the position. The thing that is sort of a little bit weird about Europe is that,
By the way, in the US, it's the same in the US. Hostile bid in the US, target board, you're not getting anything. Nada, zero.
no obligation to open up your books.
Zero, sorry, I didn't mean that.
So yeah, so
Sorry to interrupt, but yes, like as an estimate, what percentage of UK deals that are subject to that 30-day thing get extended?
see, that's what I was saying when I was saying in some
So
testing.
it's a great
Yeah.
question, but the problem is this was Kraft Cadbury. And what happened after Kraft Cadbury but the Great Recession?
Nuclear winter.
And so there hasn't been.
From an M&A perspective, anyway.
Yeah, we spent a lot of time like this.
These rules.
So we don't have the experience. I think what you're gonna find is that when prices get to the point that the board looks, staring at themselves in the mirror, realize it's a high price, they're gonna extend. The change was under the old system, before Kraft Cadbury, they could, if they chose to, extend. And
Yeah.
under the new system.
So in the old system, the board had to actively decide to put you in the put up or shut up regime. In other words,
To start the 30-day
to
clock.
start the 30-day clock. In other words, I make an offer, and I get to sit there for 6 months. But if the target board decided to do so, the target board could appeal to the takeover panel and say, now they should only have 30 days. Okay?
And no target board in this market was willing to do so, because that was viewed as frustrating, for want of a better term.
Not legally, but the shareholders would get real pissed off because they would say, excuse me, why are you restricting them and giving them only 30 days? They're making an offer for everybody. Let's sort of give them time to set it, to evaluate it. And so the boards were put under extreme pressure, and they would only rarely utilize that mechanism, or they would use it only if the bidder was sitting there for 2 months not doing anything, or nowadays instead it's automatic, and the board has to take the opposite sort of view, which is let's allow it to extend, and there's no incentive to do that if it's a hostile offer. And
So-
I mean, there is pressure, but
Now, we talked about, we talked about diligence and the pressure around diligence and the 30 days. And I mentioned it, but I glossed over it. In the UK, a bid must be fully financed. So it's not just a question, you don't get due diligence, you have a 30-day clock, you also have to organize all your money. And it's that combination that makes the bidding environment difficult in the UK unless the target board grants them, and we don't know what they're going to do.
Going back to the previous question about shareholder activism, in the UK, sort of the junction between shareholder activism and takeovers, is there any scope for companies to develop internal mechanisms, defense mechanisms, so things like poison pill in America, or does the disempowerment of the board leave them with no scope looking to the future?
It's the latter. So basically in the UK, even if there is such a mechanism that's been put in place during a quiet time, that is disallowed during a bid unless shareholders vote to approve it, which they will never ever do.
But there's a point, actually, there's an interesting point, however, that so you cannot defend against the bid. But if the activist is not making a bid, the rule doesn't apply. Because that rule applies only in the context of takeover bids. The takeover code applies only in the context of takeover bids. So if I'm making an offer to buy more than a majority of the company, okay? So it's an interesting question you asked. I don't know that a poison pill would work, because a poison pill is a mechanism that is designed to act as disincentive to accumulate more than a certain amount of stock if you're then proposing to make a bid. You see, the problem with activist shareholders is that there's very little, in the US, even in the US it's difficult to defend against activist shareholders, because the only way you can defend, you can't put a gag around their mouths. And so they,
You can't dilute them.
they buy 5% and then they start screaming bloody murder because the board hasn't distributed cash or enough cash, or the board hasn't made enough acquisitions, or if it has made acquisitions, it's made too many, or if it hasn't, I don't know, they'll invent something. And so that's the problem, is that it's very difficult to actually have a structural defense.
But the frustrating, I agree, it's a very nuanced question. So the frustrating action rules kick in the context of a bid. And in the UK system, you can accumulate shares up to 29.9. When you buy 30%, you must launch a bid, and in that context, the board must step down from any frustrating action. But if you had an abusive 28% shareholder, I suspect, you could come up with some things that the takeover panel couldn't object to, because there's no bid. In the U.S., and I know but in the U.S. you can accumulate shares, and there's nothing that there's nothing that obligates you to make a bid. And that's why boards in the U.S. came up with poison pills. They operate the same as the mandatory bid threshold in the U.K. So in the U.S. you set a threshold, 30% is too high, that's our view across the board in the U.S. So boards, if they're going to have a pill, they put it in at 15 or 20%, which allows you to accumulate, or now at 10. It allows you to accumulate, but only up to a point where you could really cause trouble. Then the pill can be an issue. In the UK, the idea was different. It was like, no, you can accumulate, you get to 30%, launch a bid, and then we force the board to stand down. That was the rationale.
Okay, now just a question on the business side of things. So you mentioned that in the UK they aren't allowed to put obstacles in the way of the bidder.
Yeah.
What about slightly non-traditional stuff like a Pac-Man defense? How would that work? Would that be allowed?
Yes.
Wow. Because Pac-Man is technically a counter defense.
If the bid's still launched, no. And we use
During, yes, we did, you're right.
So,
But once the bid is launched.
yeah, so if the target board, the rule is, if you want to go into the nitty-gritty of the rule, if the rule is that if the target board is on notice that an offer has been made, so all you need to get is an email or a fax that an offer has been made or is about to be announced, then you go into no frustrating action mode. So what Scott and I did in another defense, because we are evil, is we
No, only when it suits our clients' legitimate.
Your alignment is your clients. Yes.
is we were under threat from in a takeover situation by a bank called Marfin Popular Bank in Cyprus. The bank that we were representing was called Bank of Cyprus. We knew we were under threat. And so what we did is we used the no frustrating action to our advantage, and we did exactly what you said. We turned around and we made an offer for the other company. We made an offer for the other company.
Basically shut them up, essentially.
I'm not proud of this, okay? Come on, it was, well. We made an offer for the other company. We made an offer for the other company at no premium, and we blocked them from making an offer for us. They were going to make an offer at no premium too.
So because you, right. But if you know you're vulnerable, then you do a Pac-Man. You just have to do it before.
Yeah.
Okay.
That what we did there probably wouldn't. I don't know if it would.
It's probably not enough.
hold in a more sophisticated jurisdiction.
Okay.
Because the question would be asked, is like, well, doesn't that mean that you weren't noticed that you're, anyway, it's a little bit complicated. But
Just another curious question though. So you guys were mentioning about activist shareholders that are also evolving. And you also mentioned that, friendly people have advantages because, well, you're friendly. Is it, okay, this is just from left field. Well, is it theoretically possible to have a friendly activist shareholder?
Friendly towards the board,
Yeah.
absolutely. But they're not really activists. They're an active shareholder, they just align themselves with what the board wants to do. And indeed, that's a strategy that boards will deploy, especially in this market. It's like you have an activist that's misbehaving, one of the things the board should be thinking about is let's go talk to another couple of core shareholders, BlackRock, whoever it might be, and get them on side, and then you neutralize the more annoying. But so, I guess I spoke too quickly. You wouldn't necessarily characterize them as activists, you might, but they're active,
You're just friendly, but you're active. Okay.
there's another question somewhere around that. Sweet.
How difficult is it to negotiate commitment letters given the environment of MAC and reverse termination fees, especially from different parties' perspective?
I think the difficulty with commitment letters, at least in the UK, in a situation like the Pfizer AstraZeneca transaction, which again we're not involved in, but I would imagine the difficulty is just the length of time. In other words, it's getting the bank comfortable enough to provide a loan essentially on an unconditional basis, bar a MAC or something like that. In such a short period of time. That is the main challenge. That's why putting together a $109 billion bid in 30 days is just.
But I would say
monstrous
it's
task.
easier in the context of a Pfizer situation where it's a strategic bidder,
Mm.
but forget it in the context of private equity, where
That's
they're,
very good.
right, where they're trying to finance a bid off the back of the target company, right? That's what, so
So if there's one accusation that has been leveled at the changed takeover code, is that it might not kill deals by strategics, it just makes them more difficult, but it's certain, to your point, it's certainly, that's the accusation or the criticism that it's leveled against it, is that it certainly has dampened, if not killed off, private equity bids, unless they are on a friendly basis.
So you used the word break fee, which we haven't talked about. Break fees, compensate a bidder for putting a bid forward and having that bid fail, for instance, in the context of a higher bid, right? So the number one bidder comes in, the target kind of likes it, and the bidder says, well, I'm not gonna offer $10 because that's the most I can pay, and somebody else might pay 12, and so I'll make my bid, but if I get topped, you have to pay me a fee. It's a break fee. Those have been outlawed in the UK. So once upon a time, they're very big in the US. We use them as a tool. We all think they're very good. And the UK adopted a break fee regime, which was limited to 1% of the consideration. But those were post-Cadbury. The Takeover panel never liked them. They always thought that they were an abuse. You were sort of taking shareholder money, which we fundamentally disagree with. But in any event, that was the view. And post-Cadbury, they've been eliminated, except in narrow circumstances where the board formally auctioned. But anyway, they've been eliminated.
Even the reverse break fees, reverse termination fees?
No, reverse termination fees are not outlawed, because they're paid to the target by the bidder.
But they're not really relevant in a UK context because you have to have your financing there and you actually see it.
And the problem,
Whereas in
So-
the US, you have a commitment letter and it's got a bunch of outs in it, and it may be that the bidder fails. And in that case, the bidder owes a reverse break fee to the target, right?
that's right.
But that in the UK regime, it's kind of,
The fundamental difference is that you cannot enter into an agreement with the target. in the UK. That's outlawed. So because you can't enter into an agreement with Target, you can't agree to reverse termination. That's the problem.
Sorry, just coming back to the point, in the UK, you have to have the capital, on the table up front.
Yeah.
What is, I mean, if the deal does fail, and what happens to capital? And if you've taken a lot of debt, you've suddenly got a lot of money, nothing
Sorry.
to do with it. Yeah.
Sorry.
Paid a lot of interest.
So what are bidders doing? Because it's a great question. I don't mean to try and be cute about the answer. It's a great question. So, and it costs real money, right? So you're getting ready. So let's take the ugly American comes over here and they sit down with counsel and they say, so tell us what it's to take. So, okay, you may have 30 days. You won't be able to do due diligence. There's nothing that the target board can do, so don't worry about all those poison pill defenses that you know about in the US. But you've got to be fully financed, you've got to pay all your fees, you've got to incur all the costs, and you're just going to put the company up for sale, and anybody can come in and counter, and you can't get compensated. No break fee will compensate you for the money you have to pay, come out of pocket. That hurts. But that's the system.
Do you see that system being adopted more across Europe?
Yeah. Well, so all the questions are good. I think we have not seen, I don't think, a continental European jurisdiction adopt the no break fee rule yet. But we also haven't seen a lot of deals. So the first time somebody can argue in the Netherlands that a break fee was the reason that Dow Egberts was taken over. They're already owned by Sara Lee, I think. But anyway, the Dutch Tulip Company was taken over because of a break fee. Then you might see somebody in the Netherlands say, we have a system that's based on the UK. They got rid of break fees, we're getting rid of break fees. So
But
they all look to the UK.
Yeah. Well, yeah, but there's a lot of flip-flopping in Europe as well. In other words, there's a lot of companies that during the Great Recession there's a lot of countries that during the Great Recession which earlier were trumpeting their openness to takeovers and how they were no frustrating actions aren't we an open capital markets, that as soon as the Great Recession hit and the company and the big national champions started going down south and the Asian bidders and the American bidders started looking in, said, well, actually, and they started setting up, reversing course completely. So for example, Spain now has a system where you can defend. Italy changed its mind 3 times, as it is prone to doing. But they literally in 2010 put out legislation that said actually you can defend, and then in 2011 they put out legislation again that said, well, you can't really defend, but in some cases you can. And it's just muddying the waters a little bit.
So it's possible definitely to think of Europe right now is going through some of the almost like the adolescent growing phases and figure out what sort of regime they want on a continental level.
I think
That's
both from a regulatory and from a capital markets perspective.
I mean, and look, you see the debate just as is the UK going to stay in or out, or I mean, I think it's still an open question as in a lot of people's minds whether one single regulatory system that allows for easy takeovers is a good thing. I mean, I think a lot of people would say, the folks in France would say, we don't really care what you guys think in the UK or in Germany. We're going to protect our national champions. And Germany will say, we don't really care what France wants to do. So as long as those national interests, I think, play a role, and they will, I think, for our collective lifetimes, I think you will see significant differences nation to nation.
Sorry
about that.
Well, no, thanks very much, everyone, for your questions and for listening to our speakers today. I'm sure you'll all join me in thanking them for it was a really fascinating insight into current trends, their perspectives and their experiences of the M&A world. And feel free at the end now, if you're approaching individual speakers, just to ask some questions. But otherwise, we'll call it a day here. Thanks very much.
Thank you.